Gentlemen, we have only the one case on the docket for this afternoon, so if counsel for the appellant is ready, we may proceed.
Yes, sir. I'm Barry Kiefitz, representing the appellant Get Alcine. I'd like to reserve 3 minutes for rebuttal, if I may. Ms. Alcine worked for the employer for 2 years as a nurse's aide before November 5, 2002, when she had an admittedly compensable accident. She was assisting a patient onto a lift. The patient started to fall, and she felt a sudden crack in her neck going down her back. She immediately reported the accident to the employer, and at that point was terminated. The employer representative later said that they had decided on termination before the accident. It had nothing to do with the accident. The employer did, however, send the claimant to a doctor. She went to see Dr. Kluger. Dr. Kluger diagnosed an acute neck injury, placed the claimant on a no-work status.
For how long was that? No work status?
In one part, it says until she sees a neurologist. There was a later note that said for 1 week, with the doctor assuming that she would be seen by a neurologist within a week, and anybody would assume that. The claimant took the note to the employer.
Did the record reflect the doctor said that he put her on for 1 week because he assumed she'd see a neurologist?
No, no, sir.
Okay.
No, sir. It didn't say that. But the initial note also says, on a no-work status until she sees a neurologist. The claimant took the note back to the employer. The employer refused to authorize any follow-up care. A petition for benefits was filed seeking temporary benefits, neurologist, and correct determination of the average weekly wage. Claimant remained out of work for 3 months, a little over 3 months, and then she found a job at the Lakeside Pavilion, where she continued to work through these proceedings. 18 months after the accident, May 26, 2004, the employer carrier referred the claimant to a neurologist, Dr. Candell. He treated the claimant for approximately 4 months, treated her neck, released her with a 3% impairment of the body as a whole for the neck, and the employer carrier paid that rating, and they paid it at a greatly increased compensation rate because claimant's attorney was successful in increasing the average weekly wage by more than double. A pretrial had been completed by both the parties, submitted to the judge. Subsequent to that, in January of 2004, the employer carrier sought to unilaterally amend the pretrial by filing a unilateral amendment, raising as a defense claimant being barred for benefits under 440.09.4. They filed another one like that in August. That one, they said, a little more information based upon claimant's deposition given in August. That's all they said. They didn't say any more than just based upon the claimant's deposition. Claimant's counsel filed an objection, but there really is no objection authorized under the rules for these kind of matters. Opposing counsel never sought leave of court to file the amendment raising the defense, certainly raising it in the fashion that they did. The case came on for hearing before the judge March 4 of 2005, at which time the only issue was the 3 months, approximately 3.5 months of temporary benefits since the neurological care had already been provided.
At what point was the adjuster deposed?
I'm sorry?
At what point was the adjuster deposed?
The adjuster was deposed we had sought to depose the adjuster, and that was quashed, and that was in approximately August. They then deposed the adjuster in December of 2004.
So the employer carrier deposed the adjuster?
Yes, when it suited their purposes, they deposed the adjuster. Now, no live testimony was presented at the hearing, but the claimant was there, and we specifically advised opposing counsel she's here, and if you want to ask her anything, you can ask her anything. We brought her. There was no need for the claimant to present any testimony based on the deposition testimony that went into evidence. That covered everything we needed to cover regarding her her aspect of the 3 months of temporary benefits that were sought. Now,
Wait, let's go back to the amendments to the pleadings, because that's really your first issue, it seems to me, or second issue, it seems to me.
it's a second, but that will be that is a primary issue, Judge. Yes, sir.
You didn't object, move to strike, or take any action with respect to the amendment. Is that correct?
No, I did object. I did object. There's an objection in the, and they noted in their brief also, there's an objection in September to their raising 440.094, and noted particularly when we weren't even permitted to depose the adjuster. They had moved to quash the adjuster's deposition, and they succeeded with that. But there is no, procedurally, there's no provisions authorizing any kind of objections or such as that. What really happens when you submit a pretrial, if there's any problems with the initial pretrial, then you appear before the judge, and the judge irons these out. So that if claims are not specific like they should be, or the defenses are not, then the trial judge at that time will take action. Or if a party seeks to file a unilateral amendment one way or another, I would suggest they sort of act at their peril without proceeding before the judge. In this case, opposing counsel easily could have proceeded before the judge. They actually proceeded on their motion to quash. They could have proceeded on their motion to amend the pretrial if they wanted, but they chose not to. Now,
was there any attempt in discovery to obtain greater detail on this defense?
well, opposing counsel says in their brief, I mean, you can, try to discover. I'm not sure, how you go about that. There was, one aspect of the Lakeside Pavilion aspect I did know about, and that's where they said that she had an accident there. There was no medical care, no compensation provided, nothing like that. But that aspect I knew about. But I'm not sure, whether claimant, has to spend lots of money to try to discover what it is. The claimant is required to file a claim with great specificity, and when you're on the pretrial, you have to specifically claim what you're claiming, and I think the employer carrier has the same obligation. The statute under 440.192, in response to a petition.
Johnson, then you think in raising the issue of fraud, that they had to enumerate the specific misrepresentations when they pled the defense on the pretrial?
Well, yes. Well, let me say this, first of all. Opposing counsel in their brief say it's enough if we tell you that we're raising a defense and we place you on notice we're raising a defense of false and misleading statements. I don't think that's enough. But they haven't even met their standard in their brief. Their pleading just says 440.09. It doesn't even say 440.105, which would put us on a little more notice, doesn't say misleading statements, and doesn't say what the statements are. But in specific response to your question, Judge, they say in their brief, heavens to Betsy, we cannot give a detailed factual explanation. And yet, when it suited their purposes, that is exactly what they did. The day before the hearing, they filed with the judge a trial memo, and the part of the fraud part is on page 447, at which they laid out for the judge what their position was regarding fraud. That, of course, was served on claimant's attorney at about 4 o'clock to 5 o'clock the day before the 9 o'clock a.m. trial. So there was no notice, but if they can do that when it suits their purposes for the trial judge, then I would say yes, they can do that to put the claimant on notice. But, let me further point out, we are dealing with a nuclear defense. And we are dealing with a very unique defense with this fraud aspect. It is unlike any other fraud in any field of the law. In the circuit court, a fraud defense has a higher evidentiary standard, and the circuit court cases say you can only utilize it in the most egregious situations. Fraud in workers' compensation is interpreted in a much more broader sense. If the claimant doesn't disclose what he had for breakfast, everything, and that in some way has to do with his making a claim, he may find himself guilty of insurance fraud and out of the ballgame totally. And so I would say where those are the circumstances, where we have this very broad nuclear defense.
Isn't it a big difference, though, counsel, between disclosing what you have for breakfast and disclosing whether you've been injured in 2 different car wrecks before on these specific things? Isn't that a vast difference?
Well, yes, there is. Let me say this. They talk about being injured in 2, quote, car wrecks. There were 2 accidents, and claimant told about the accidents. Their complaint is that she didn't talk about that she hurt her neck in one of them. What did those accidents involve? The records are in evidence, and the records were provided to Dr. Kandel by opposing counsel before Dr. Kandel's evaluation. So he had the actual records. Nevertheless, they complained that the claimant didn't tell Dr. Kandel that she hurt her neck. Now, if you look at the records, and I've outlined this is under point 6 in my brief, and I go through the...
Was it a matter of omission, or did she make a specific declaration that she had not been so injured or involved in an accident?
No, she didn't say she wasn't involved in an accident. She said she was involved in an accident. Everybody they have 2 accidents. There may have been one that she didn't say for either in the deposition or before the doctor. She told people she was in 2 accidents. They're complaining that she didn't say she hurt her neck. And she went to the hospital on one occasion. She had diffuse complaints, primarily regarding the chest. She had neck complaints. Another incident, I think, was the 1999 incident. We're not even sure there was an accident that occurred. She did go to the hospital, did report there was an accident, but she went back the next day and they said this was hysterical, and that's what it was. And it's not even clear. There was no police report ever submitted or anything. I mean, based on her history, there was one.
Why would you have not been, you're about out of time, why would you have not been well served by accepting the offered continuance in order to look into this matter?
I'm sorry, what, sir?
Why would you have not been well served by accepting the offer of a continuance of these proceedings to look into this matter before you had to defend on it?
We're there. Everybody's there. The claimant's already waited. The hearing was March 5 of 2005. The accident for which she's seeking 3 months of temporary benefits was November of 2002. She's already waited 3 years. And so the judge gave us a Hobson's choice. Do we want to come back again sometime and visit? Maybe a year down the road, maybe 2 years down the road, who knows? Or do we go forward? And, let me say this. The problem lay with their pleading, and their failing to properly plead with any degree of notice, the fraud defense. And even the judge agreed on 521 of the record. He says, that's no notice. If opposing counsel had not properly pled and came before the judge and said, Judge, I'd like to have a continuance of this case so that we can adjust our pleading, he would not be entitled to it. 440.25 says, only where a continuance can be granted, only where the necessity arises from circumstances beyond the control of the parties.
Okay. You're into your rebuttal time if you want to say something.
Okay, sir. All right. I'll reserve the rest of the time for rebuttal. Thank you.
May it please the Court. My name is Bill Rogner. I represent the employer carrier in this matter. Judge Van Nortwick, you asked about the amendments. I want to make sure the Court understands the timeline here because it's very important. The first amendment to the pretrial, which, by the way, the rule says, Rule 60Q-6.113, subparen 4, says the pretrial may be amended without leave of court up to 30 days prior to trial. So he says we have to get leave of court. The rule says we don't have to get leave of court. In any event, the first fraud amendment was filed January 7, 2004, 14 months before trial. And what it said was, claim denied under 440.094, which is the statute that says if the claimant violates 441.05, then the claimant forfeits benefits. We filed a witness list amendment and an exhibit list amendment at the same time. He did nothing. Took no depositions, didn't file a request to produce, did absolutely nothing. Never wrote a letter, never demanded clarification, Did nothing. So then what happens is the adjuster's depot is taken. Now this transcript's not in the record, but there's references to it in the transcript. The adjuster's deposition was actually taken for the first time February 26th. We don't know if questions were asked about the defense in that deposition. There was a protective order hearing on a second deposition of the adjuster. This was July 27th. Okay? Claimant's counsel didn't show up. We don't know why. Nothing in the record about why he wasn't there. But the protective order was granted and the notice of taking deposition of the adjuster for the second time was quashed. Now the claimant's depot comes next. That's August 6th, 2004. 6 days later, we file our second amendment to the pretrial. That second amendment says claimant forfeits benefits based on the deposition testimony and references 44009 and 44105. Again, a list of witnesses, a list of exhibits, followed by nothing. No depositions, no request to produce, no motion to compel, no outraged letters, no motion to strike, nothing. He files an objection, September 14th, that says, it doesn't say it's not specific enough. All it says is, I object to the amendment because I haven't been able to depose the adjuster about it. Now keep in mind, the quashing of the notice of taking deposition, that was entered before the claimant perjured herself, in our opinion, in the second deposition. Okay? Second deposition happens, we raise the defense. He doesn't try to set the adjuster's depot again. Never tries. The record is clear on that. Instead, we set the adjuster's deposition. That was conducted on December the 23rd. Claimant's counsel was there. Transcripts in the record. Not one question about the fraud. Not one question about the defense. Not one question about the pretrial amendment. No, Madam Adjuster, what do you think my client did to justify denial of the benefits? Nothing. Doesn't ask a single question about it. And then the trial is in March. 14 months after the defense was raised for the first time. 7 months after it was raised for the second time. He says, you didn't do enough to put me on notice. Our job is to raise the defense. Green Iguana case says we can't show up at trial and say, guess what? The claimant committed fraud. If we know about it, we have to put them on notice. That's what we did through the pretrial amendment. You mentioned the continuance. Why didn't you accept the continuance? Well, the judge didn't have to grant a continuance because we raised it properly. They did no discovery. They had no valid basis to object to our amendment. But the judge says, you know what? Okay, fine. This isn't abundantly clear as to what they're alleging. They haven't raised it with specificity like you're saying they should have. How about a continuance? So you can go ahead and take all the depots you want or do whatever you think you need to do in order to cure any prejudice here. He says, can I take a break? He goes outside. He confers with his client. He walks back in and says, no thanks. Don't want a continuance. I want to try the case. He did so at his own peril. The judge did what the judge is permitted to do. It's a discretionary decision. Every one of his 7 points of appeal, he says, is de novo, or 6 out of the 7. And in fact, 7 out of the 7 are either CSE or abuse of discretion. Now, Your Honor, you asked some questions about what was the nature of the statements. She did admit that she was in 2 motor vehicle accidents. She was in 3. She denied being injured in either. And we established through records, through the testimony of a subsequent employer, that she actually had a subsequent workers' compensation injury, injuring her back, that she was taken to the hospital twice via ambulance as a result of these motor vehicle accidents that she denied being injured in, that she complained of the exact same symptoms that she complains of in our claim. Why does all this matter? Well, it shouldn't, because these are factual questions. These are factual issues. It's not your role to determine what the facts are. The facts are this. The claimant lied. And the claimant lied to get benefits. And how do I know that? I know that because that's the judge's job to tell us. And that's what the judge told us. The judge told us she lied, therefore she lied. Their theory was she was mistaken, she didn't remember, there's a language barrier, they weren't significant enough. That's their story. That's the story they present to the judge. The story we present to the judge is she lied for the purpose of getting workers' compensation benefits. Not your role to determine which of those things is true. It's the judge's role. And that's what he did. He determined which of those theories was right. He said, well, ours was right. So what he does is he writes a letter to the parties that say, I'm denying all benefits for 3 reasons. 1, claimant was terminated for cause. 2, loss of earnings is unrelated to the accident. 3, claimant made false or misleading statements and has forfeited all benefits. Mr. Employer Carrier's attorney, do the order. They take issue with that. That's their first point on the appeals, that was inappropriate because the employer carrier's attorney drafted an order, and if you read the order, you'll find that benefits were denied for those exact 3 reasons, but of course, denied in much greater detail. And the judge signed it, not exactly as written, but substantially as written. There were some minor tweaks to the order, which shows that he at least reviewed it and took the time to correct what he thought needed to be corrected.
Does the record reflect that there was a request by the claimant to respond to the proposed order or to object?
Yes, and he did object. I'll give you the timeline, Judge. The trial was March the 4th. On April the 11th, the judge wrote the letter saying, I've ruled and here's why. The order requested by the court, specifically recognized by the rules, Rule 60Q-6.103 says he can do this. Order was filed April 28th. On May the 3rd, they filed their objections to the order. On May the 10th, we responded. Trial counsel responded saying this is our response to his objections. And on June the 15th, the judge signed the order. So, Your Honors, this is the way this works. Not just with this judge, but with virtually every judge in the state. I tried 4 cases in the last 5 weeks. I was asked to draft 4 orders. In 2 of the cases, I got detailed letters saying this is what I think. And the other 2, the judge goes, Mr. Rogner, do the order. And adopt your arguments. I agree with you. And that's the way that it's done every single day. That's the practice. And this court has told us, and many times in cases cited in the brief, that that's appropriate. If the judge has to draft an order or draft a letter that's as detailed as the order that's ultimately entered, why ask the lawyers to draft the order in the first place? The whole point is, let the lawyers do the work. I've ruled, and if it's inappropriate, if they overstep their bounds, if they, write poorly, I can fix it.
And the informal practice is the proposed order is submitted, a copy is provided claimant's counsel. Claimant's counsel doesn't object until the judge prepares the order, or the claimant's counsel can object at that time and take issue with some of the language in the proposed order.
It's just like what happened here. The proposed order is filed, and you're supposed to provide a copy to claimant's counsel or defense counsel, depending on who won. And that's what happened here. And then he filed his objections. Judge didn't sign the order before he filed his objections. He waited till he filed his objections. And then he waited till we filed our response to his objections. And then he entered the order. His basic problem is that the judge didn't change it around a lot. If the judge would have changed it around a lot, then it would prove that the judge was really entering his own findings as opposed to the findings of the employer carrier's lawyer. But the judge said, I want these 3 reasons for the denial. 1, 2, 3. The order has those 3 reasons in it. 1, 2, 3. With more detail. I mean, that's the way it's supposed to work. And it's the way it works. Now, some judges do it differently. Judge Terlizzi in Brevard County has a very long ruling conference where he, basically rules longer than it takes us to draft the order. And you'll see these things on appeal where his ruling conference might be a whole volume. That's Judge Terlizzi. That's how he does it. Judge Langham up in Pensacola, now our new chief judge, he does his own orders every single time. But the bulk of the judges, and I practice before them all, do it that way. They decide who wins. They either do it in a short letter, or they tell you at the end of the hearing, I find for the employer carrier or I find for the claimant. That's the way it works. He calls this fraud defense, and you've already sustained it constitutionally, a gotcha defense, and talks about how it's unfair, it's the nuclear defense, it's the gotcha defense, et cetera, et cetera, et cetera. This defense has been upheld by this court on constitutional grounds, construction grounds, every kind of ground you can come up with. This statute's been determined to be valid. And you've said to us over and over and over again that these are factual determinations to be made by the judge below, the trier of fact. and that statements made, these are the statements that are relevant, that the judge can rely on to determine if the claimant made false or misleading statements. Not misnomers fraud defense, by the way. It's not a fraud defense. Fraud is a very, powerful legal concept. This statute punishes fraudulent statements, and you've recognized this, misleading statements, and false statements. If any of those things are done with the purpose of obtaining workers' comp, then you lose your case. And the statements don't have to be under oath. Now, the statements can be in a deposition as they were here. The statements can be made to other people in the case, like a recorded statement of an adjuster, as long as I jump through the evidentiary hoops to get it before the court. But it's also to the doctors. And in this case, Dr. Carlin testified that based on his assessment of the claimant's subjective complaints, her presentation to him and his physical exam, she was fabricating her injury, fabricating her complaints. That's his word. It's a fabrication, and the judge accepted that. That is a factual determination. The record evidence supports that she was fabricating her complaints. He says, well, you can't use that to make a finding of fraud under 440-105 or 440-09, because fabricating your complaints or having inconsistencies in your presentation to the doctor is not a statement, that the law only punishes oral and written statements. But I would assert that when the doctor asks you, does this hurt? Show me where you hurt. Tell me about your pain. And you lie about it, that's enough. In this case, they take great issue with the physical exam. Dr. Carlin did what's called a straight leg raising test. You do it in the supine position, and then you do it in the seated position. And if you're legitimately injured, you get the same response both seated and lying down. And hers was different. And he said, it's impossible. That's not possible. It's a non-organic finding. And what it tells me is she was fabricating her complaints. She's fabricating her injury. Well, that means she said she hurt when she didn't. That's a statement. And the judge is allowed to rely in part, which is all he relied on that in part to determine that she made false or misleading statements. Finally, the denial of the indemnity benefits. The judge made the following finding. I find she was terminated for cause. And the evidence supports that finding. The evidence was, not the evidence they wanted you to believe, but the evidence that we wanted the judge to believe, was that this lady, for some reason that was hard to understand, got a puppy and put that puppy in the garbage at work. And they ended up calling the authorities over it, and then they found out it was her, and they fired her because of it. And they want to imply that it was all made up, but the judge found that it was valid and accurate, and that she was fired for cause. And as long as that finding is supported by the record, that's a CSE issue, then it should be affirmed. The judge found, based on the totality of the evidence, the fabricated pain complaints, the incredible inability to remember being taken to the hospital by ambulance a couple of times, the denial of being injured before, all of these things, he concluded that her loss of earnings was unrelated to her injury, and he denied benefits. Now, there was a period, and I concede and agree with claimant's counsel that the record is unclear. At page 440 of the record is the medical note that took her off for 1 week. There's another note that says off until you see a neurologist from the same doctor on the same date. But keep in mind that if the case was properly denied on the misrepresentation defense, then none of that really matters, because she forfeited all benefits regardless of whether she was taken off a week or for longer. And we hope that you'll affirm the decision below.
Thank you.
Do I have a few minutes? Pretrial may be amended without leave of court, but you have to do it properly. That's the problem in this case. I can't just amend the pretrial. I'm making a claim for benefits, and then that goes. You asked about whether we could examine and take discovery. Look at page 58 of the record, where opposing counsel objected as going beyond the scope of his direct examination of the adjuster when we were asking some other questions. He didn't ask about any fraud defenses initially. etc. Opposing counsel talks about the judge relying in part on this inconsistent effort, and I didn't get a chance to talk about that. I do talk about it in the brief. Let me point out there's nothing in the record the statute says oral or written statements. I don't know whether it was oohs or ahs or what it is in the record. It doesn't say whether she said yeses or nos or whatever. I have a mixed emotions about arguing this because this section also applies to the employer and the adjusters. And if I get an expert to say that the adjuster wasn't giving her full effort, is that insurance fraud? Now, I don't think by any stretch of the imagination the legislature was looking at that and intending anything like that be viewed as insurance fraud when it depends upon the examiner and the standard is simply the examiner. If that's the case, then if you have to pay a super examiner $25,000 to examine an admitted quadriplegic and you find an inconsistent response or not enough effort and he says, hey, not enough effort, is that insurance fraud? I think not. I don't think the insurance fraud defense belongs in this case. Opposing counsel did not talk about the Isaac case that I cited in our brief several times where this court excluded consideration of the fraud defense where it was not timely and properly brought. And I would say that should be true in this case as well.
Thank you very much, counsel. That concludes our cases for the day. Court's adjourned.